Good morning.
Good morning.
Today's topic is relevance and how the federal rules of evidence define and limit the admissibility of relevance at trial. How many of you before today, before law school even, got into an argument with a friend or family member and they brought up something that you did or you said a couple of years before and you were outraged and you said, no, that's not relevant. Maybe you meant there's no relationship between what I did or said then and what we're talking about today. Or maybe you meant that's been so long ago that it's just not fair that you bring it up again today. Well, we'll see these themes kind of weave their way through our discussion today. But luckily, the federal rules of evidence give us a few more guidelines for determining what is relevant and admissible at trial. Let's start with Rule 401. Ms. Bewley, how does Rule 401 define relevant evidence?
Rule 401 states that evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action.
How would you describe that definition?
I would say that evidence is relevant if it is used to prove something in a case and is needed to prove something.
So for us to really understand what it means, we need to dissect it a little bit. And I think there are three key phrases in this definition. Can you tell me what they are?
I would say one of the key phrases is tendency to make a fact more or less probable.
More or less probable, phrase number 2. There's one before that. Any tendency more or less probable, and what do you think the third one is?
And the fact is of consequence.
Of consequence to the determination of the action. So let's start with any tendency. What do you think that means?
If it helps to prove or not prove a fact, then I think that would satisfy any tendency.
Do you think it requires a preponderance of the evidence?
No.
No. Even the slightest tendency. Any tendency. Do you think that is easy to satisfy or difficult to satisfy? Extremely easy to satisfy. The second phrase, more or less probable. Do you think it requires the evidence to conclusively establish a fact? No. Lawyers like to talk about building their cases like bricks and brick walls, so that if you think of a piece of evidence like a brick, it's rare that you're going to have a fact that is significant enough to build your whole wall at one time. And so as long as that brick makes it more or less probable, let me give you an example. Let's say when I arrived this morning, I park in the parking garage, I take my briefcase to my office, and when I get to my office, I realize I've left my cell phone in the car. So I get back on the elevator, I go back down, and in the short time I'm gone, I realize someone has rear-ended my car. I interview a couple of students standing around, and I think it's someone named Ben Smith. So I sue him for negligence. At trial, can I call Mr. Smith to the stand and ask him, did you drive your car to Belmont Law on the morning of September the 16th? Is that question relevant?
I don't think it is relevant.
It doesn't conclusively establish, right, that he is in fact the one who hit my car. And so I want more bricks, right, to build my case against Mr. Smith. I'm not going to win my negligence case with his yes to my question, did you drive your car to Belmont Law on the morning of September 16th? I'm going to have more bricks, like perhaps Mr. Smith drives a black car, and perhaps there was black paint on my bumper. You see what I mean? I've got to build my case. So the third phrase, of consequence to the determination of the action, what does that mean?
A fact is of consequence if it's either necessary elements under the applicable substantive law or other facts from which a necessary element may be inferred.
Exactly right. So now we're talking about the substantive law. Let's see how this works. In a breach of contract case, Can the defendant testify that when he said, "I accept your offer," he secretly was joking and he never intended to accept the offer? If the defendant verbally said, "I accept your offer," does it matter that he secretly was joking and he never really intended to accept the offer? Is his subjective intent here relevant? No. And how do you know?
Law of contract.
Contract law. So you turn to contract law, and we know that the secret, unspoken intent of the parties is irrelevant when we're discussing contract formation. Here's another one. A traffic accident. The victim sues Joe, the owner of a trucking company, but he's suing them for the negligent acts of the driver under a theory of the doctrine of respondeat superior. At trial, can Joe testify that he, the owner of the company, is the responsible driver and has never been in a car accident before? Is that testimony relevant?
I don't think it is relevant.
It isn't. And how do you know? What body of law would you turn to?
Tort.
Tort law. That tells us under the doctrine of respondeat superior, what we're looking at is the actions of the employee, not that of the owner. And so, of consequence, you see, relates directly to substantive law. Who makes the determination of whether evidence is relevant, Ms. Bewley?
The judge.
The judge. You know what's coming next? Is it a 104A or is it a 104B question? And warning, warning. Think about this answer.
Well, we were just discussing whether it was...
You knew it was coming.
And we were divided, but I felt like it was a 104B decision because the judge would make the determination of whether it was relevant evidence, and then the jury would weigh the evidence. But you're giving me a look that like it's 104A, so...
How many of you thought 104A? How many of you thought 104B? So it depends, right? The general rule is 104A, but if it's an issue of conditional relevancy that we talked about a couple of classes ago, then it's a 104B question. But at least you knew I was going to ask, right? You were totally prepared for that. And so on appeal, what standard of review would the appellate court use to review the trial judge's decision to admit evidence or not on relevancy ground?
Would it be abuse of discretion?
It is. And is that a forgiving or a difficult standard to satisfy?
Pretty forgiving.
It's the most forgiving standard around. So can either direct or circumstantial evidence be relevant?
Yes.
Yes. Direct evidence being witness saw Fred standing over the victim and shoot the victim versus witness saw Fred standing over the victim with a smoking gun. Both extremely relevant here under 401. If a party concedes a particular fact, does that make the fact irrelevant, the concession itself?
No, it doesn't.
It doesn't make it irrelevant. It might be excluded under other rules, but as to the issue of relevancy, how do you know that it's not irrelevant?
It could be used to show the extent of the injuries or something else for that matter.
It could be, and the rules also tell us, the advisory committee notes, that the fact to which the evidence is directed need not be disputed. It doesn't change the issue, the ultimate decision initially of whether it is relevant. What about basic biographical information? Is that relevant?
It is relevant.
It is, and how do you know that you're right?
In the notes for the rule, it says background evidence such as photographs, views of real estate, murder weapons, and basic biographical information concerning a witness is relevant, according to Rule 401.
So we have the definition of relevant evidence. We know that it's pretty broad, pretty easy to satisfy. So Mr. Pope, then what is Rule 402's function? What does it do?
The general admissibility of relevant evidence, it says where evidence is admissible unless the following provides otherwise. And it gives 4 categories.
So stop right there. It gives us a general rule, right? And so under the general rule, if evidence is deemed relevant under 401, then what happens? It is. The general rule says it's admissible. If evidence is deemed to be irrelevant under 401, then what does the general rule in 402 tell us?
Irrelevant evidence is not admissible.
That's exactly right. So if it's relevant, the general rule is that it's admissible. If it's not relevant, not admissible. Pretty straightforward. But all great general rules have what? Exceptions. And so Rule 402 gives us some significant exceptions. Will you help me walk through those? What does it say?
Evidence is admissible unless provided by either the United States Constitution, a federal statute, the federal rules of evidence, or other rules prescribed by the Supreme Court. And
so when it says the Constitution, what portion of the Constitution do you think might preclude the admission of relevant evidence?
The 4th, 5th, and 6th Amendments.
Exactly right. So that we're not going to require criminal defendants to incriminate themselves, even though I'm sure they have highly relevant evidence. The Constitution here is going to outweigh the general rule of admissibility for relevant evidence. Act of Congress by these rules, and we're going to get to some of these rules today that exclude relevant evidence, and by other rules as prescribed by the court. Ms. Carter, will you help me with this problem? Read it please first, if you will, and then take issue number 1.
Okay. Jane Smith has been charged with killing her husband, John. John was 40 years old and was having extramarital affairs with 3 women, and one of them lived in their neighborhood. He was shot to death in his library around 9 p.m. on the night of September 5th, 2012. Jane denies that she killed him and contends that she was upstairs putting their 2 children to bed at 9 p.m. After she tucked them into bed, she went downstairs and then discovered John dead on the floor of the library. She checked his neck for a pulse and then called their alarm company and requested an ambulance and police cars. 10 minutes before he was shot, John was talking on his cell phone with one of his lovers, Cindy Thomas. One neighbor notified police that she heard the sound of tires screeching around 9 p.m., and another neighbor reported hearing the sound of a gunshot but did not see a car fleeing. John Smith had a $500,000 life insurance policy, and he named his wife, Jane, as the sole beneficiary. The murder weapon has never been found.
So there are lots of issues embedded in this sort of fact pattern. The first one, let's focus on the life insurance policy and whether it is relevant here to the murder. And for this problem, I want you to assume that you're representing the prosecution and you're making their arguments.
If I was the prosecution, I would say that this evidence is very relevant if we're looking at Jane, his wife, to be the killer, because she's the sole beneficiary of his life insurance, and that's $500,000 that she would inherit upon his death.
And so let's put this in terms of our relevancy definition. In order for evidence to be relevant, what must be true about this life insurance policy?
The life insurance has to have a tendency that's more or less probable to prove that Jane would do it, so that she's the killer.
That's exactly right. It has to make it more or less probable that Jane murdered John. And so what would the prosecution be offering this particular evidence to show?
They would offer it as motive for Jane to kill John.
That's exactly right. Here is evidence of Jane's motive to kill John. And you see that will make it more likely that she is in fact the one who killed John. That's the evidence being relevant. Exactly right. Issue number 2. What about the phone call that John had with Cindy Thomas right before his murder? And now you're representing Jane. What is your crucial question?
Well, I want to know, is Cindy the one that lives in the neighborhood? But were they having a contentious conversation? And if I was representing Jane, I would want to show that Cindy had some motive to kill John as well, whether it was he was breaking up with her or they got into an argument. She found out about the other 2 lovers that he had. She already knew he had a wife, but I would use it to show that she had some motive.
Okay, so in terms of relevance, is this phone call relevant?
Yes.
And how do you put that and frame it in terms of our definition?
Because it has a tendency to show that Cindy would be more or less probable as the person who committed the murder.
Jane, by offering this evidence, is showing exactly what you said, that someone else had a motive and that it makes it less likely that she is the one who killed John. Do you think the prosecution is going to object on relevancy grounds to this phone call?
I would say they would object, but that if I'm representing Jane, I would just respond and lay a foundation as to why I'm bringing it in.
But might they have an argument? Might they want to offer this evidence to advance one of their arguments in terms of that Jane murdered John?
They could use it to show that Jane was jealous that he had other lovers, so that could go to her motive as well.
It could help their motive, and so that's a good example of how evidence is sometimes relevant for more than one purpose. So now back to this noise of the screech of tires. Is it relevant?
If I represent Jane, I'm going to say yes, it's relevant.
Because why?
Because it could show that there was someone else that's more probable that killed John, and that the screeching tires is their getaway car. So if you can, get some kind of tire match off the treads, you could show that someone else was fleeing the house around that time.
And so it makes it less likely that Jane is the one who murdered John. In terms of the screeching tires, does it matter that another neighbor testified that she heard a gunshot but did not see a fleeing car? Will that affect the admissibility on relevance grounds of the screeching tires?
It won't affect the relevancy, but because that'll be an issue for the jury to weigh the 2 testimonies of the different witnesses who heard the screeching tires and who heard the gunshot.
Exactly right. It's not going to affect the relevancy, but the jury can certainly weigh the other testimony in terms of determining how much weight they want to place on the screeching tires. Final issue here. Jane called the alarm company instead of 911. If you represent the prosecution, is this relevant?
Yes.
And so what would you be offering this evidence to show?
Jane is more likely than not the person who did kill him, because by calling the alarm company instead of 911, that's delaying any type of rescue measures that could come to John's aid to save him. So I would say that she did it to delay rescue and ensure that he did die.
I think you're exactly right. And you can see here how any tendency, might there be an argument that Jane could make here that it does not in fact show that it made it more likely that she killed John?
Yes, Jane could argue that she called the alarm company because she has 2 children upstairs, so she could be worried about an intruder. And so the alarm company can not only call the police, but they can also call the ambulance for John. In her grieving state, that was her best option that she could think of.
Exactly right. Very well said. Again, another example of how evidence can be relevant for more than one purpose. Now, you could have had other arguments. These are not all of them, but I think these are some key ones. And hopefully we can draw a couple of conclusions from the exercise. First, the crucial issue is identifying the fact of consequence, right? And asking yourself, what are you offering the evidence to show here in order to determine if it is in fact relevant? Second, that evidence can be relevant for more than one purpose. That the fact need not be disputed in order to be admissible, and that it need not conclusively establish a fact. And then, as Mr. Pope told us, if evidence is deemed relevant under the general rule, that means it's generally admissible, unless it is excluded by another rule. And that brings us to one of the most significant rules that exclude evidence, and that is Rule 403. Mr. Geyer, what does Rule 403 say?
That a court may exclude evidence that is relevant if its probative value is substantially outweighed by the danger of one of six things: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence.
So what is probative value?
It's a measure of how telling something is of a fact.
Is it the same thing as relevance?
No.
No.
It's a question of degree.
Weight, exactly right. The degree of that particular evidence. So what does the rule mean? If the probative value of the evidence, Mr. Geyer, is equal to the risk of unfair prejudice, what happens under the rule?
If it's equal to, it'll be allowed.
Admitted. If the risk of unfair prejudice outweighs the probative value,
It'll be admitted.
admitted. It's only when what is true?
It must be substantially outweighed.
It must be substantially outweighed. Notice that it is a sliding scale. So the higher, the more probative value a piece of evidence has, then what must be true?
The greater the prejudicial effect.
And the more difficult it's going to be to exclude that evidence with high probative value. We call this an admit unless rule because of this high level of unfair prejudice or any of the six issues that you mentioned. Who bears the burden under Rule 403?
Party objecting.
Party objecting to the evidence. And what does substantially outweighed mean?
It can't just prejudice. A party has to be like an unfair amount of prejudice.
We don't have an exact formula, right, in terms of how much is required for substantially outweighed, but we know it's a balancing test with pressure on the side to admit. And so what is the most common objection, do you think, under Rule 403?
I would say unfair prejudice.
I think you're right. And you wanted to tell me this. Does that mean it must be merely detrimental to a party's case?
No.
No. What do the rules tell us that unfair prejudice means?
It has an undue tendency to suggest decision on an improper basis.
Exactly right. If it appeals to the jury's sympathies, arouses its sense of horror, provokes its intent to punish, or otherwise may cause a jury to base its decision on something other than the established propositions of the case. Does Rule 403 apply to civil cases, to criminal cases, or both?
Both.
Both. Does it apply to bench trials or jury trials, or both?
Both.
Both. But if it's a bench trial, what argument may you not want to make under 403?
That the evidence has an effect of misleading the fact finder.
That's exactly right, because we think that the judge, in his role as fact finder, which is what he does with a bench trial, could be able to set that aside. Great job. So what happens if the judge determines that evidence is probative for one purpose and admissible, but not admissible or relevant for another purpose?
The judge can give limiting instructions.
The judge, in fact, can. But what if the judge believes that the jury can't follow the limiting instruction? That because of the nature of the evidence, he's concerned that the jury may not be able to set it aside and only consider it for the one proper purpose.
Well, then he can exclude it if he thinks that's going to have.
And under what rule would he exclude it under?
403.
403 is exactly right. This is a classic example of unfair prejudice, and when the judge might, in fact, exclude it under Rule 403. So that brings us to some more problems. Mr. Ramcharan, will you take this one, please?
Absolutely. Prosecution of defendant for murder. Defendant claims self-defense. At trial, the prosecution wishes to offer
several color photographs of the victim taken during the autopsy. The photos show the victim's body from several angles and reveal bullet entry and exit points on the torso and head. Defendant objects to the photos on Rule 403 grounds. First question is, how should the court rule?
So before we get to how should the court rule, is there anything you might like to know about these photos?
I mean, I guess I would want to know the level, like how graphic they may be, how, whether they're in color, whether they're, how close up,
By virtue of the fact that it is the coroner taking the photos during the autopsy, what also might you want to know?
I might say whether or not they actually reveal anything about the cause of death. It was self-defense, location of the wound, something like that.
Or maybe even has the coroner altered the body, right, during the course of the autopsy? If the coroner had altered the body, what would that mean in terms of the probative value?
I think that would go down substantially.
But we don't know that, right? All we know is that there are some photos. So let's assume the body has not been altered for purposes of answering this question. How do you think the court is going to rule?
I'd like to have this submitted. I think that it shows enough information that is necessary to the furtherance of the trial, that if it might be a little graphic or if it might be a little bit misleading, I don't think that's enough prejudicial damage to have it thrown out.
So in terms of probative value, where are you?
Pretty substantial.
Pretty
Because of
substantial.
how much facts it would produce.
And then in terms of risk of unfair prejudice,
I rate it pretty low.
and so under our 403 balancing test, that means,
I don't think it's close. I think it's admissible.
does it matter that the photos are in color? What does that do to probative value?
I think it increases the probative value. However, I also think it increases the prejudicial damage as well. But I think it keeps the balance pretty much the same.
I think you're exactly right. So if the photos are tight close-ups of the wound and do not show a recognizable location on the body, what does that mean?
Your probative value goes down because you lose some information, like it says where the wound is located. And depending on whether they're in color, I guess it could also increase prejudicial effects because it might be more gruesome or upsetting to a jury.
But if it does not show a recognizable location on the body, might that decrease risk of unfair prejudice?
I guess so, yeah.
What would you say? If they're tight close-ups, are you still going to admit or are you still going to exclude?
I think it depends on the argument. I think it depends on if they show any sort of, blood or chemical residue or gunpowder, or if it's something like that. But if it's just a close-up of a wound for no good reason, I wouldn't admit it.
What if the prosecution introduced a diagram rather than the photos? What does that do for both probative value and risk of unfair prejudice?
I think it's a good diagram. You have pretty high probative value. And I think it kind of eliminates any sort of, gore factor or something like that. So I think your prejudice goes down a lot too.
You're exactly right. Does the prosecution have to do that? Do they have to rely on a diagram when they have photos? No, they don't. But certainly this is one way that they could reduce sort of this risk of unfair prejudice. The prosecution probably doesn't want to, though, right? I mean, the prosecution wants the jury to see the real color photos. So you've got all the answers exactly right. Can you take this one, please, sir?
Same case. The perpetrator had placed the victim's body in a bag and threw the bag in the lake. The body and bag were discovered 6 months later. The prosecutor offers the bag into evidence. The bag emits a pungent, disturbing odor that can be detected throughout the courtroom. Defendant objects on Rule 403 grounds. How should the court rule? Just reading the sentence kind of makes me a little upset, and so I feel like there's pretty high prejudicial effects coming out of it.
I think you're probably right from the smell, right?
Right,
so there are two issues, really. The bag is... What is the probative value of the bag itself?
The bag shows that the body was in a bag, although it seems like the kind of fact that they might concede anyway. I don't think they would be disputed whether the body was in a bag or not. So pretty low probative value there, I would say.
And might there be some other way that they could introduce evidence of the bag besides bringing the actual bag into the courtroom?
Yeah, I think, sufficient photographs maybe taken or expert bag testimony. I don't know. But I don't think you need to have a funky bag in a courtroom.
I think you're right. So the bag itself, pretty low probative value.
Yeah.
And then risk of unfair prejudice because of the odor.
Probably about as high as you could get.
I agree with you. I think the court's not going to be reversed if it excludes the bag here. There's one more.
All right. Negligence action by plaintiff against defendant following an intersection collision. Prior to trial, defendant admits negligence and indicates that she will only contest the extent of injury suffered by plaintiff. At trial, plaintiff wishes to call a witness to testify that defendant ran the red light, striking plaintiff's vehicle. Defendant objects on relevance and Rule 403 grounds. How should the court rule? I think that since the defendant has admitted negligence, which is the only thing I can see it would be proved by the testimony describing her running the red light, that I think it should be excluded, maybe for either, I don't know, wasting time or needlessly presenting cumulative evidence.
Defendant admits negligence. What do the comments tell us about what happens when a party concedes a particular fact? Does that deem the evidence to be irrelevant?
No, it does not.
No. So the evidence is relevant. The issue here is what is the evidence being offered to prove? And your answer is if it's only being offered to prove negligence, then it has low probative value. But I think it might be offered to show something else here. I think this is another example of when evidence can be offered for more than one purpose. Ms. Carter, you were hinting at this earlier with regard to a different problem.
It could be offered to show you'll have a chance to cross-examine the witness so they can tell, what they saw from an objective standpoint on the plaintiff's actions and the defendant's actions.
But what might that witness testify to that would be relevant with regard to the last issue, which is the injury itself?
Severity.
The severity, and also what?
I was just going to say that the speed of the vehicle as it makes contact, since she's run the red light, it's not from a stop, so that would go to the jury decision on the extent of the injury.
Extent of the injuries, where the impact occurred in terms of where she was, how close to her, how fast she was traveling. I think it still remains relevant for this other purpose. So while the defendant has conceded the issue of negligence, still relevant to the issue of the extent of her injuries. Mr. Ramcharan.
Prosecution of defendant for bank robbery. Defendant admits being the person who approached the teller, pointed a shotgun at him, and threatened to kill him if he did not empty his cash drawer into a bag and hand it over. Defendant claims, however, that she had been kidnapped by the other robbers and that they threatened to kill her if she did not help them rob the bank. At trial, the prosecution wishes to call the bank teller referred to above to describe the defendant's actions. Defendant offers to stipulate to all of the facts to which the teller will testify. The prosecution refuses defendant's offered stipulation. Defendant objects. How should the court rule?
And does this bring to mind the case and the reading for today? And the name of that case is?
The Old Chief case?
The Old Chief case. And what do we know about Old Chief? We know that Old Chief was limited to a very specific factual situation dealing with status crimes. But the court gave us some general language in terms of the party's ability to do what?
Such evidence might have some probative value and isn't necessarily inadmissible just because it doesn't exactly relate.
And a party gets to prove their own case.
Right.
They're not required to sort of accept this sort of stipulation. And so under the general rule in Old Chief, how should the court rule here?
I think the objection should be overruled because the prosecution is free to proceed how they see fit.
Exactly right. The prosecution gets to prove its case. And if they want to call the witness here, then they certainly can. Which brings us to another exception. So we have 401, which gives us the definition of relevant evidence. We have 402 that gives us a general rule for the admission of relevant evidence. Major exception being Rule 403, and that brings us to 407. Mr. Floyd, what subject does Rule 407 deal with?
When measures are taken that would have made an earlier injury or harm less likely to occur, evidence of the subsequent measures is not admissible to prove negligence, culpable conduct, a defect in a product or its design, or a need for warning or instruction. But the court may admit this evidence for another purpose, such as impeachment, or if disputed, proving ownership, control, or the feasibility of precautionary measures.
And so what is a subsequent measure?
Essentially, a subsequent measure is taken by a company after someone is injured to remedy or rectify the harmful.
Exactly right. The comments tell us, one, that had it been taken before the event that caused an injury or harm would have made the injury or harm less likely to occur. Can you give me some examples of things that might constitute a subsequent remedial measure?
Yes, we have a repair, a design change, installation of safety features, the firing of or disciplinary action against an employee, a change in rules or policies, a new or modified warning, and post-accident analysis or studies. No, post-accident analysis or studies are generally not considered subsequent remedial measures. Sorry.
And so for what purpose does the rule exclude evidence of subsequent remedial measure? Tell us that again so we're all clear.
To encourage parties to take safety measures.
Yes, but they give us some specific purposes in the rule for which the evidence is excluded. You cannot offer it, in other words, to show these particular purposes.
Oh, to show negligence, culpable conduct, a defect in a product or its designs, or a need for warning or instruction.
That's exactly right. Why? And you were trying to tell me this before. You knew it was coming. Why do the rules exclude evidence of subsequent remedial measures for these purposes?
For policy reasons, they want to encourage businesses or companies to take safety measures.
So we want to encourage parties to take safety measures, and on this particular issue, exclude evidence that really may not be relevant. When must the remedial measure occur in order to fall within the confines of this rule?
The remedial measure must occur after the accident or event that allegedly caused the injury or harm.
That's exactly right. So for what purpose does the rule indicate that subsequent remedial measures may be considered?
May be considered for impeachment and, if disputed, proving ownership, control, or the feasibility of precautionary measures.
If the judge admits evidence of a subsequent remedial measure for one of the permissible purposes, is there any other objection that the defendant might want to make?
I guess I might object on Rule 403 grounds.
Exactly, and why?
Because the prejudicial nature of the evidence might outweigh the probative value.
Exactly right. Substantially outweigh the probative value. So you're exactly right. You'll fall back to Rule 403. We'll see this throughout the semester. 403 continues to be an additional argument here for which the judge might exclude evidence. We have a few more problems dealing with Rule 403. Can you take the first one, please, Mr. Floyd?
Yes. All right. Plaintiff sues defendant, the owner of a convenience store, for negligence after plaintiff tripped and fell over a can of fruit that had fallen off the shelf on a display near the store's front door. Defendant admits that plaintiff tripped in this way, but denies its negligence led to the plaintiff's fall. To prove defendant was negligent in allowing the can to fall from the shelf, plaintiff wishes to present evidence that after the accident, defendant began placing the cans in a staggered brick-like stacks rather than one directly on top of the other. Defendant objects. How should the court rule? I think the court should sustain the objection in accordance with Rule 407 because it's a subsequent remedial measure.
It's being offered here to show what?
Negligence.
Negligence. That the way the defendant originally stacked the cans was culpable, and that is the reason the defendants restacked them. Exactly right. So objection sustained as to this first problem. What about problem 2?
Okay, same case. Defendant claims that the can on which plaintiff tripped was no longer the store's property, but had fallen out of a customer's bag after the customer had paid for his purchase. How should the court rule on a defendant's objection to the subsequent remedial measures evidence? I would allow the subsequent remedial measure evidence to prove ownership.
Exactly right. And that is the issue here. The defendant is claiming they no longer had the can. It had been purchased by someone else at this point. And so the fact that the defendant then went out and restacked the cans is some proof that they were not, in fact, telling the truth here and that they owned the cans. Problem number 3, you're on a roll, Mr. Floyd.
Same case. Defendant admits that the can fell from the display but testifies that this was the best possible way to stack cans. How should the court rule on the defendant's objection? I would overrule this objection on grounds of impeachment.
Well, I think impeachment is right. I think there's another possibility.
Maybe to show the feasibility of precautionary measures.
The feasibility. I think either of those work. Feasibility or impeachment. So where are we then? We have Rule 401, which gives us what, Ms. Bewley?
The test for relevant evidence.
It does. And Rule 402 gives us what, Mr. Pope?
General admissibility.
It does. And Mr. Geyer, what does Rule 403 do for us?
It tells us that the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the accused, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence.
Fabulous. It gives us a balancing test. And Mr. Floyd, what does Rule 407 do?
It tells us that subsequent remedial measures are generally excluded if they're presented to prove negligence.
That's sufficient. I thank you. So it gives us another exception to the general rule. That concludes our classroom discussion on relevant evidence. And now it's time to begin the oral argument portion of our class. Students in this class are assigned various oral argument problems throughout the semester. And those problems require them to take the role of either 1, objecting to the evidence, 2, arguing for the admissibility of that evidence, or 3, as a student judge who will issue a ruling on the admissibility of evidence. Today's problem deals with relevancy and issues related to Rule 401 and 403.
On the docket today, we have United States v. Dixon. A charge in this case is murder, and the defendant is claiming self-defense. Before we begin, we have a motion in limine related to 2 pieces of evidence the government is attempting to bring in. One is Government's Exhibit A, which is a close-up picture of the victim in this case. Government's Exhibit B, which is the second piece, is a far shot of the crime scene as well as the victim. I believe, defendant, this is your motion?
Yes, Your Honor.
Will defense counsel please begin with your motion?
Well, defense moves that Government's Exhibit A be excluded from evidence, and we rely on Rules 401 and Rule 403 of the Federal Rules of Evidence in support of this motion. Would you like me to go ahead and make those arguments?
Yes, please.
Regarding Rule 401, the relevance test, there's nothing about this photograph that makes the existence of self-defense, which is the issue in this case, more or less likely. So it fails to meet that test. And moving to 403, given that it lacks that probative value in determining the issue of self-defense, then the probative value does not outweigh the prejudicial value. The prejudicial value being an undue tendency due to the gruesome nature of this photograph to suggest decision on an emotional basis rather than a factual one.
Counsel for the United States, do you have a response?
Yes, Your Honor. These photos are relevant under Rule 401 as they have a tendency to make the existence of self-defense less probable. And whether or not the defendant acted in self-defense is a fact of consequence in this case. Now, as to the defendant's Rule 403 objection, Your Honor, these photos have a probative value that outweighs any prejudicial effect. The defendant is on trial here for murder, and we're not seeking to admit these photos to inflame the jury, Your Honor. We are admitting them because they are extremely probative of the nature of that fatal wound, which is important to our theory of the case, namely that the defendant did not act in self-defense.
Now, counsel, if I understand this correctly, defense counsel would like to exclude Exhibit A, the close-up photo. I'm looking at government's Exhibit B here. Why can't we just have this photo? Why do we need both?
Well, Your Honor, Exhibit B does provide some context as to the scene of the death. However, the court will notice that the nature of the wound is not visible in Exhibit B, only in Exhibit A.
And what's the relevance of that wound?
Well, Your Honor, the defendant is alleging self-defense here, and so our expert witness will testify that a self-defense wound usually will have some evidence of a gunshot powder or sooting on the skin, and without the actual photo of the wound, the jury will not be able to determine for themselves whether or not that sooting or gunpowder streaks are present.
Defense counsel, you have a response?
Yes, Your Honor. If the government wishes to introduce evidence of the presence of or absence of gunpowder on the wound by virtue of an expert witness, it can just as easily do so with the other photograph that you have before you, which is Exhibit B. It is a wide-angle shot giving the entire view of the body. An expert witness could just as easily point to the part of the body where that gunpowder is present or missing, and wouldn't lose any probative value whatsoever.
Counsel for the United States, do you have any response to that?
Yes, Your Honor, I do. Without being able to actually see the wound itself, the expert's testimony will not make sense to the jury. They need to be able to look at the wound to determine whether or not the existence of the gunpowder is present. And, Your Honor, I mean, it goes to the theory of our case that a gunshot wound issued in self-defense would be done at close range, and without the presence of that gunpowder, the jury can't determine whether or not that actually happened.
Thank you, counsels. The court's ruling that I believe this evidence certainly is relevant. It does have some tendency to prove the existence of a fact that is in dispute in this case. There's also the court's ruling that the Exhibit A will be admitted into evidence. While I do find that there is some prejudicial nature of this photo, this court's finding that it does not substantially outweigh the probative value that can be had by admitting this photograph into evidence. Certainly, the expert testimony can provide some light as to discerning what is to be looked at in this photo as well. So we're going to admit both photos into evidence. Thank you.